Honorable Justices of the International Court of Justice, my name is Jimena Batres and I represent the Republic of Belarus in this appeal challenging the legitimacy of criminal indictments issued by the United States Federal Court against four Belarusian officials. These indictments, filed in January 2022, allege conspiracy to commit an aircraft piracy in connection with the diversion of Ryanair Flight 4978 on May 23, 2021. Yet, they raise troubling questions about jurisdiction, legal identity, and the integrity of international law. The alleged offense occurred in Belarusian airspace, under Belarusian authority, and involved Belarusian nationals acting in their official capacity. The United States asserts jurisdiction based solely on the presence of four American citizens aboard the flight. This appeal calls on this court to reaffirm the principles of sovereignty, due process, and legal restraint. Second, statement of the issue. The issue before this court is whether the United States may assert criminal jurisdiction over foreign officials acting within their own sovereignty territory, and whether indictments lacking legal identity and enforceability meet the standards of international justice. Third, value of arguments today, the need for a de novo review. Honorable Justices, the arguments presented today are not merely academic, they are urgent, relevant, and foundational to the credibility of international law. We are not asking this court to defer to the conclusions of another nation's judiciary. We are asking for a de novo review, a fresh, independent examination of the facts, the legal standards, and the jurisdictional claims. This court must revisit the facts in their entirety, not through the lens of a domestic court's assumptions, but through the principles of international law. The legitimacy of this appeal rests on the understanding that no single nation legal system can dictate what is right or wrong for another sovereign state. The rule of law must be universal, not unilateral. Each argument we present, sovereign jurisdiction, legal identity, statutory relevance, and symbolic overreach, is grounded in precedent and principle. Together, they form a cohesive challenge to the notion that one's country court can extend its reach across borders without consent, clarity, or consequence. This is not just about Belarus. It is about the future of international cooperation, the credibility of global justice, and the protection of sovereign legal systems from politicized prosecution. The court's de novo review is essential to restoring balance and reaffirming that justice must be principled, not performative. Fourth, statement of the facts. On May 23, 2021, Ryanair Flight 4978 was diverted to Minsk under Belarusian aviation protocols. Four Belarusian officials acting in their official capacity were later indicted by a U.S. federal court. Two of the individuals were improperly identified, one listed as FNU, ONU, first name unknown, last name unknown, and another without a surname. Belarus has refused extradition and no trial has occurred. Fifth, legal analysis and argumentation. Argument 1, violation of sovereign jurisdiction. Legal precedents, Corfu Channel case, UK versus Albania, ICCJ judgment of April 9, 1949. United States versus Alvarez McCain, 405 US 1992. Explanation. This argument proves our point by showing that the US has overreached. The Ryanair incident occurred entirely within Belarusian airspace, and the actions taken were lawful under Belarusian jurisdiction. The US indictments bypass diplomatic channels and violate the principle of territorial sovereignty, affirmed in Corfu Channel and challenged in Alvarez McCain. Why this argument is superior to the status quo? The current practice, where powerful nations assert jurisdiction beyond their borders, replaces cooperation with coercion. Our argument restores balance by reaffirming sovereignty and demanding lawful restraint. This court must hear this case now to prevent a precedent that erodes territorial integrity and involves global instability. Argument 2. Lack of legal identity in indictments. Legal precedents. Hamdi versus Roxville, 542, 2004. The prosecutor versus Thomas Lubanga Dailo, ICC judgment of March 14, 2012. Explanation. This argument proves our point by exposing a procedural failure. Two of the indicted individuals were not properly named, one listed as FNU LNU, another missing a surname. These omissions violate both U.S. due process and international standards for legal identity, rendering the indictments legally defective. Why this argument is superior to the status quo? The status quo tolerates vague indictments that compromise individual rights and judicial credibility. Our argument demands precision, transparency, and fairness. This court must hear this case now to reaffirm that justice begins with identity and that due process is not optional. If there are no further questions, I will sit retired and my partner will come and do their second speech. We pray that you vote for sovereign immunity and allow a country to have power over its own country and vote for the court to hear the entire case before the full court.
You may begin, second speaker.
Honorable Justices of the International Court of Justice, my name is Jordan Hamill and I represent the Republic of Belarus in this appeal of the legitimacy of the United States Federal Court issued indictments against 4 Belarusian officials. These indictments filed in January of 2022 allege conspiracy to commit aircraft piracy in connection with the diversion of Ryanair Flight 4978 on May 23, 2021. Yet they raise troubling questions about jurisdiction, legal identity, and the integrity of international law. The alleged offense occurred in Belarusian airspace under Belarusian authority and involved Belarusian nationals acting in their official capacity. The United States asserts jurisdiction based solely on the presence of 4 American citizens aboard the flight. This appeal calls on the court to reaffirm the principles of sovereignty, due process, and legal restraint. Please cross-apply my partner's arguments and then add these 2 additional arguments. Argument number 3, no violation of US law by Belarusian officials. Legal precedent, Barcelona Traction Light and Power Company, Belgium versus Spain, ICJU judgment of February 5th, 1970. This argument proves our point by showing that the US lacks standing. The Belarusian officials acted within their own jurisdiction under their own laws. No US statute was directly violated, and without treaty-based framework, the US cannot prosecute foreign officials for domestic actions. The status quo allows nations to stretch their legal reach based on political interest, not legal connection. Our argument restores clarity and jurisdictional discipline. This court must hear this case now to prevent the erosion of legal standing and the misuse of criminal law as a foreign policy tool. Argument 4, symbolic changes undermine legal integrity theoretical framework. Michael Cunningham's thesis on Edgicide. This argument proves our point by revealing the deeper danger of politicized legal action. The indictments are unenforceable. Belarus has refused extradition and no trial has occurred. These charges serve no judicial function. They are symbolic gestures that distort legal norms and risk becoming tools of narrative control. The status quo permits symbolic prosecutions that serve political optics rather than legal outcomes. Our argument insists that justice is meant to be real, enforceable, and principled. This court must hear this case now to protect the integrity of international law from becoming a stage for performative diplomacy. Counsel for the Republic of Belarus, Honorable Justices, the Ryanair incident deserves scrutiny, but scrutiny must be grounded in law, not politics. The United States Federal Court lacked jurisdiction, violated due process, and indicted individuals without legal identity. These actions undermine the credibility of international justice and set a dangerous precedent for sovereign nations and legal cooperation. Our four main arguments today were: 1. Violation of sovereign jurisdiction. The alleged offenses occurred entirely within a Belarusian airspace under Belarusian authority. 2. Lack of legal identity in indictment. 2 of the 4 individuals were improperly named, breaching procedural integrity. 3. No violation of U.S. law by Belarusian officials. The actions taken did not violate any of the U.S. statute and occurred outside U.S. jurisdiction. 4. Symbolic charges undermine legal integrity. These indictments are unenforceable and serve political optics rather than legal outcomes. Our value was a de novo review, a full and independent reconsideration of the facts and legal standards. This is important because it affirms that no domestic court, regardless of power or influence, can dictate international norms without scrutiny. A de novo review ensures that this court does not simply inherit the assumptions of another system, but instead applies the principles of international law with impartiality and rigor. Our legal foundation was built on the respected precedent, Corfu Channel case, the UK versus Albania, affirming territorial sovereignty as inviolable. United States versus Alvarez McCain, exposing the dangers of unilateral jurisdictional overreach. Hamdi versus Runfield, reinforcing the necessity of due process even in national security cases. The Prosecutor versus Thomas Lubanga Dillo, establishing international standards for legal identity and fair trial. Barcelona Traction, Belgium versus Spain, clarifying the legal of understanding under international law. The major issues before this court today has been: can one nation assert criminal jurisdiction over foreign officials acting within their own sovereign territory based solely on the nationality of passengers aboard the diverted flight? Is it important to rule in the favor of Belarus today because failing to do so would legitimize extraterritorial prosecution without consent, clarity, or enforceability? It would invite selective enforcement, politicized indictment, and the erosion of sovereign legal systems. The Ryanair incident deserves scrutiny, but scrutiny must be grounded in law. The US federal court lacked jurisdiction, violated due process, and indicted individuals without legal identity. These actions undermine the credibility of international justice and set a dangerous precedent. We respectfully request that this court recognize the jurisdictional overreach and recommend dismissal or referral to a proper international mechanism. Let us reaffirm that international law is not a tool of convenience. It is a covenant of principle. Justice must be principled, not performative. We pray that you apply our legal precedents, logic, and arguments to reach the conclusion that this case before you today must be decided in an international court and not in the US federal court. We assert that it is justice for the individuals involved and fits into the legal rights for the countries represented today. Therefore, the only conclusion you could reach today to allow the entire court to hear this case as soon as possible. Thank you.